Connor. Good morning. Today is April 9th, 2025. It's approximately 10:04 a.m. This is an adjudicatory hearing before the Massachusetts Gaming Commission relative to the alleged noncompliance of Betfair Interactive LLC doing business as FanDuel with Massachusetts General Law, Chapter 23N, Sections 11A1 or I and 13F and 205 CMR 238.321. During this proceeding, I will refer to Betfair Interactive LLC as FanDuel. My name is Jordan Maynard, and I serve as the chair of the commission. I am joined today by my colleagues, Commissioners Eileen O'Brien, Brad Hill, Nikisha Skinner, and Paul Broder. The entire commission will preside over the hearing and decision of this matter. This hearing will be conducted in accordance with 205 CMR 101.01, Massachusetts General Law, Chapter 30A, Sections 10 and 11, and 801 CMR 1.02, the informal fair hearing rules. This hearing is being conducted via remote collaboration technology. I will now explain the process that will govern this proceeding, and it's rather lengthy, so bear with me. First, a notice of hearing was provided to FanDuel in advance of today's hearing. It identified the alleged noncompliance incidents that will be the focus of the Commission's attention at this hearing, and the relevant statutes and regulations. A pre-hearing conference was also conducted. Pursuant to Massachusetts General Law, Chapter 23N, Sections 4 and 16, and 205 CMR 232, the Commission may hold this adjudicatory hearing, and at the conclusion of the hearing may decide to issue a civil administrative penalty, impose conditions on FanDuel's license, suspend FanDuel's license, revoke FanDuel's license, reprimand FanDuel, and or assess a fine on FanDuel. I see that attorneys are present here today on behalf of the parties. I will ask that you please identify yourself and advise the Commission as to whom you represent.
Good morning, Chair and Commissioners. Zach Mercer for the IEB. I'm also present on the meeting today, IEB Director Caitlin Monahan and Chief Enforcement Counsel Kathleen Kramer.
Thank you, Counselor.
Good morning, Chair. Jed Nozel, outside regulatory counsel to FanDuel. I am joined today by Rich Cooper, who's Vice President of Regulatory, also counsel, who has an appearance and will present in this matter. On the witness side, we have Ben Roth, Senior Regulatory Counsel, as well as Reginald Leeden, Director of Corporate Compliance. We're also supported by Courtney McGillicuddy, Regulatory Investigations Associate.
Thank you, Attorney Nozel. I will please ask, I see FanDuel's in the room together. When you do speak, please identify yourself, at least at the beginning, so we know who's speaking. At the conclusion of my opening comments, this proceeding will commence with opening statements. Both the IEB and the licensee will be afforded an opportunity to make a statement outlining the case they intend to present. Either party may decline to make an opening statement, or in the case of the licensee, defer until the beginning of its case. After opening statements, we will move to the presentation of evidence in this matter. First, the IEB will be called upon to present its findings as described in its investigative report and any other applicable evidence. Any commissioner may ask a question of any witness being presented at any point during or following the presentation. At the conclusion of the testimony of each witness, the licensee, through its counsel, will be afforded an opportunity to cross-examine the witness as to any matter addressed in the investigative reports or to which he or she has testified. At the conclusion of the IEB's presentation, the licensee will be given an opportunity to present its case. The licensee may call any witness and present any other evidence it desires. At the conclusion of the direct testimony of each witness, counsel for the IEB will be provided an opportunity to conduct a cross-examination of the witness. As stated before, any commissioner may ask any question of any witnesses at any time during the examination or at the conclusion of the examinations. We will allow very limited redirect and recross of a witness if requested. Either party may raise any objection it desires at any time. However, the basis for all objections must be clearly stated. Finally, at the conclusion of all the evidence, the IEB and the licensee will each be provided an opportunity to make a closing statement summing up their respective presentations. Before we begin, I understand that there are pre-marked exhibits that have been prepared in advance of this hearing. Those exhibits are identified on the exhibit list that has been circulated. They are as follows. An IEB video interview of attorney Ben Roth, FanDuel, September 6, 2024. FanDuel full employee play policy, February 2024. FanDuel correspondence with IEB, September 20th, 2024. FanDuel employee play monitoring procedure, August 9th, 2023. FanDuel correspondence with IEB, July 1st, 2024. A FanDuel commercial director job description, FanDuel employee wagers spreadsheet, a FanDuel correspondence with IEB, March 4th, 2025, a FanDuel correspondence with IEB, March 17th, 2025, an IEB noncompliance investigation report, March 21st, 2025, a FanDuel employee play policy, abbreviated, February 2024, a FanDuel employee play monitoring procedure, abbreviated, August 9th, 2023, a FanDuel internal Slack channel images, February 24th and February 27th, FanDuel interactive employee play map, animated, and a notice of hearing dated March 14th, 2025. Are there any objections to Exhibit 1 through 15 being marked and entered into evidence?
No objection from the IEB, Mr. Chair.
None from FanDuel. Thank you.
Thank you, councilors. Those exhibits shall be admitted into evidence. In order to maintain a clear record, I ask that documents are referred to by exhibit number. At this point, I will ask if FanDuel would like to stipulate to Exhibit 10, which is the IEB report dated March 21st, 2025.
Thank you, Chair. FanDuel has had an opportunity to review the report, and the company does stipulate to its accuracy.
Thank you, Attorney Nozel. If any party would like to have any additional documents entered into evidence during the course of the hearing, I would ask that they be properly introduced and marked at that time. Okay. The Commission anticipates that its inquiry at this proceeding will be limited to the matters addressed in the investigative report and contained in the notice of hearing. In the event that a line of questioning conducted by the Commission moves into an area that has not been included in the report or notice, but is material to the final determination of this matter, the licensee may request a recess in the proceeding in order to review the issue. A proceeding of this nature necessarily requires the consideration of a wide variety of information and takes several forms. In this case, some of the information and documentation may include commercially sensitive information. The public discussion of such information may place an entity at a competitive disadvantage if such information were to be publicly discussed. For the Commission to be able to execute its legal obligations effectively and diligently prior to making a final finding, it must be at liberty to fully inquire relative to any of these sensitive matters without compromising the individuals or entities involved. To do otherwise would be at a minimum unfair and potentially unlawful. Accordingly, my colleagues and I may elect to exercise the discretion afforded in accordance with 205 CMR 101.01, paragraph 7, to close this proceeding to the public to fully address certain matters. Under this same regulatory section, FanDuel or the IEB may request that portions of this hearing be closed to the public as well, and any such request will be considered in turn. I will also state that no final decision will be made at the conclusion of the public portion of the hearing. Instead, at the conclusion of the proceeding, the Commission will privately deliberate and ultimately issue a written decision. If at any point during the Commission's deliberations, it determines that additional testimonial or documentary evidence is desired, It reserves the right to ask for such evidence prior to a final decision being made. We will now swear in all the witnesses. Anyone who will be testifying at this proceeding, please raise your right hand. Give me just a second to look at the boxes. You do so.
So could I ask that Ms. McKillop also raise her hand? I did have some questions for her. Thank you.
All right. Okay. Do you solemnly swear that the testimony you will provide before the commission at this proceeding be the truth, the whole truth, and nothing but the truth?
I do.
Yes, I do.
Yes, I do.
Thank you. All right. All have responded in the affirmative. Before we begin, does FanDuel have any preliminary issues or objections?
Thanks, Chair. I'd like to just quickly address 3 issues, and I'll start with the one that the process you've discussed. FanDuel has identified a discrete area that will be touched on in this proceeding that it would like to request a closed session for. It involves sensitive technical information pertaining to the internal employee monitoring policy, methods, and practices, public disclosure of which would put the company at a competitive disadvantage. This is an in-house developed protocol. It has value to FanDuel. We don't want that to be disclosed to competitors. In addition, in connection with disclosing any sort of internal company monitoring policy, we feel that making that public also can effectively weaken its effectiveness by disclosing the techniques and whatnot and the way the company monitors its employees. So we would ask for that discrete area to be handled in a closed session. I've discussed this with Attorney Mercer. I've made the legal team aware of it as well. It does implicate a couple exhibits. Exhibit 4, that's the policy itself, I think that you identified. There's a question in Exhibit 5. Question 3, the IEB report at pages 4 and 5. The interview, to the extent that that's discussed here, has a couple areas of inquiry there. And then FanDuel's Exhibit 2. Again, it's a fairly discrete part of what we will present on direct testimony. I imagine Attorney Mercer will touch on it in his direct case based on the report, and we just ask that that portion of the hearing be conducted in closed session.
All right, Councilor Noble, give me 1 second.
Sure.
I'm marking these exhibits.
Sure.
All right, so the way we typically handle this, as you know, Councilor Nozel, you're no stranger to us, is that when we get to those relevant portions, you'll ask for that. And I have some language that I have to read into the record. The commission will take a vote and we'll go from there. So I will trust you as well as the IEB to flag those if we start to get to that point in the conversation. Is that fair?
Yes, Chair, thank you.
Thank you.
Chair, just one, actually 2 just quick additional issues. You're going to hear reference today, I think, to the company's internal control. That is not listed as an exhibit. It's a document on file with the commission. I think the commission can take administrative notice for that, but just wanted to raise that to the extent that for purposes of the hearing, we want to mark that. I think that's fine. If not, again, we feel comfortable it's going to be part of the administrative record and be incorporated as a on-file approved document by the commission.
Councilor, I'm fine with that. I'm looking at my fellow commissioners to make sure that I got the green light since we're all 5 conducting the hearing. Are we good with those internal controls being discussed in the matter in which Jed just proposed?
Yes.
I am too. All right, I'm getting yeses across the board.
Yeah, and of course, Commissioner, I just want to raise one other issue. Ms. McGillicuddy wasn't identified as a witness in this case. We, of course, want to accommodate the commission but she wasn't included as part of the original witness list as well.
Yeah,
Okay.
but it does indicate anyone else who might have relevant information, and she's referenced quite a bit. So I'm
Sure.
happy to sort of pause, right, Attorney Nozel, if you feel like something I'm asking should be in private session or whatever. I'm happy to sort of have there be a pause between question and answer.
Yeah, I appreciate that, Commissioner. My point was to just identify that, and also to the extent that we need an opportunity to consult with her, I'd appreciate the leeway there as well. Thank you.
Now, if you need some time, Councilor Nozel, for prep or otherwise, you stop me, okay?
I won't be shy. Thank you, Chair.
All right, thank you, Attorney Nozel. All right, let me see where I left off. All right, we went through the preliminary issues. With that, I will ask the IEB to make its opening statement if it desires to do so. So I'll turn it over to Councilor Mercer.
Thank you, Mr. Chair. At this point, the IEB will be prepared to waive an opening and proceed straight to the presentation of the evidence following any opening from Mr. Nozel and the FanDuel team.
Thank you, Councilor. Attorney Nozel, do you have an opening statement?
Thank you. Yes, I'm going to turn it over to Attorney Cooper in order to make that presentation.
Yes, thank you very much. Good morning, Chair and Commissioners and staff. I'm Rich Cooper, Vice President for Regulatory at FanDuel and House Counsel, appearing on behalf of FanDuel. I'll be very brief in this opening statement. I wanted to thank the IAB for its engagement on this issue, and I just wanted to take a few minutes to give the Commission an understanding of what we expect the facts to show here this morning. The issue before the Commission, of course, is whether FanDuel complied with the requirement to employ commercially reasonable methods to prohibit its employees from placing bets on the FanDuel platform in Massachusetts, and whether FanDuel had adequate internal controls regarding employee play. I don't expect, with respect to the evidence, that there's going to be any disagreement with the IEB on the facts here. In short, FanDuel had a new employee in April 2024 who, despite training, policies, and procedures to the contrary, placed approximately $240 in wagers on the FanDuel Sportsbook in Massachusetts. This wagering was detected by FanDuel's monitoring processes, and the company self-reported this violation to the Commission. I also don't expect there to be any disagreement with the IEB on the control environment that FanDuel has set up. In this regard, FanDuel expects to call as a witness Reginald Leedon, FanDuel's Director of Corporate Compliance, as its witness today. Mr. Leedon, I expect, will describe the robust control environment, which includes new employee training, annual training thereafter, clear prohibitions on conduct that's prohibited by Massachusetts statute and regulation, a robust policy on what employees can and cannot do, and substantial resources that assist employees in understanding what the policy permits and what it doesn't. What happened here, I expect the Commission will learn, was an employee mistake, certainly not anything intentional, and not anything that had an impact on the integrity of gaming. The company has accepted responsibility for this mistake, and we respectfully submit that the Commission will see through the evidence today that FanDuel had reasonable methods to prohibit these kinds of mistakes from happening, and similarly reasonable methods to detect and report to the Commission. After the Commission has reviewed all the evidence, we'll address it in particular. But I wanted to give the Commission a framework for what we expect will hear. Thank you.
Thank you, Counselor. All right. I would now ask the IEB to move forward with calling any witnesses it intends to call.
Thank you, Mr. Chair. The IEB calls Kevin Murphy.
Good morning, everyone. My name is Kevin Murphy. I am a civilian investigator for the Massachusetts Gaming Commission and a former member of the Massachusetts State Police. As a sworn member of the State Police.
Oh, sorry. Go on. Apologize.
As a sworn member of the State Police, I worked the majority of my career in the Division of Investigative Services. It was in 2016 that I was assigned to the Investigation and Enforcement Bureau of the Mass Gaming Commission under the Division of the State Police, and worked there until July of 2021. My role with the IEB encompassed mostly compliance and non-compliance investigations of casino operators and qualifiers, as well as vendors, and more recently, sports wagering investigations. I have participated in the training, in investigations and interviews, case management, as well as ethics at both the MSP and the MGC level. I retired from the state police in July of 2022 and returned as a civilian investigator for the MGC in September of that year. As Attorney Mercer will point out, I participated in this non-compliance investigation that involves FanDuel.
Thank you, Mr. Murphy, for that introduction. And as you just suggested, on August 1st, 2024, following the commission's public meeting where they opted to move this matter to an adjudicatory hearing, you became involved in this investigation?
Yes, I was.
And regarding the scope of the review that you assisted in conducting in this matter, could you please explain the methodology of the investigation for the commission, please?
Certainly. Requests were submitted for information from FanDuel. FanDuel responded and the materials were reviewed. Follow-up interviews were conducted with Attorney Ben Roth from FanDuel, which Attorney Mercer had previously marked as Exhibit 1. And additional follow-up requests were provided after the interview.
Thank you, sir. And during this investigation, were you able to participate in that interview of Mr. Roth and also review the policies that were provided by FanDuel?
Yes, I did.
Okay. And in the initial stages of this investigation, were you provided with an overview of the incident in question?
I was. It was on
Could you explain that? Sorry.
Certainly. On May 24th of 2024, FanDuel notified the commission that a FanDuel employee had engaged in an impermissible wagering activity in Massachusetts on its platform, placing 12 wagers between April 19th and April 21st of 2024. The wagers were detected by FanDuel on May 14th of 2024.
Okay, sir, and understanding those essential facts of the incident, did the investigation then endeavor to further understand FanDuel's policies surrounding employee wagering?
Yes.
All right, and without getting into it, understanding Mr. Nosel's later request to move some of this into a private session, did this involve a review of FanDuel's employee play policy, which had been previously marked as Exhibit 2?
Yes, this policy was in place at the time of the incident.
And we don't have to go too much further into it. As I said, I think that this may be something that there'll be an ultimate request to go into private session. So we can address this at a later point. So I'd move directly to detailing the incident matter. Did you have an opportunity in the course of this investigation to get more detail as to the facts of the specific incident?
Yes, I did.
And did you learn the position of the employee that was involved in this matter?
Yes, the employee worked as a commercial director.
Okay. And did FanDuel provide the IAB with a job description for that position, which has been previously marked as Exhibit 6?
Yes, they did.
And did you come to learn what kind of essentially the what the responsibilities for that role are?
Yes, the commercial director was responsible for business performance decisions and VIP program strategy.
And in the investigation, did you learn whether or not this is a position that requires licensure from the commission?
No, it does not.
And further detailing that commercial director's employment with FanDuel, did you learn when that employee began work at FanDuel?
Yes, on April 8th, 2024, they began work.
Okay. And as you stated prior, there is an employee training for FanDuel a policy involving employee wagering. Did you learn when that employee conducted or completed that training?
Yes, it was concluded on April 21st of 2024.
Apologies, sir. I'm sorry. Just to refresh your memory, was it April 15th, 2024?
Oh, sorry. Yeah, it is. It was. He completed the FanDuel training on April 15th, and then it was. I had jumped ahead a little bit on you. So go ahead.
So did you? So at what point did his wagering begin in Massachusetts? That employee.
Say that again, attorney.
Did the employee's wagering in Massachusetts begin on April 19th, 2024?
Yes, it did, and then it concluded on April 21st, 2024.
There we go. Thank you. And as stated earlier, the wagering activity, which has been included in Exhibit 7, which has been submitted to the commission, could you provide further detail as to what that constituted?
Sure. It was 12 wagers. They totaled $240. Winning wagers totaled $182.77, and all wagers were on the NBA.
And sir, at one point on May 3rd, 2024, did this employee have an account balance of $95.45?
Yes, the withdrawal occurred 11 days prior to FanDuel detecting the violation, but nah, go ahead.
So I'm sorry. So that $95.45 was withdrawn 11 days prior to FanDuel ultimately identifying the violation.
Correct.
And sir, at the time of the conclusion of our investigation, had any action been taken in regard to those funds at that time?
No.
And did you come to learn in the period between the submission of the IEB's report and this hearing today that FanDuel may intend to or may have taken additional action regarding those winnings that I'm sure that they will detail in their presentation of evidence?
Yes.
At this point, the IEB's presentation would necessarily go into a detail of two policies that FanDuel submitted that are instrumental to the IEB's review of this incident. Those are documents that have identified as by Mr. Nozel as potentially material for a private session. So I defer to the commission how we'd like to address that at this point.
Thank you, Councilor Mercer. I'm going to give an opportunity for cross-examination of anything that was said publicly here first. Attorney Nozel or Council for FanDuel. Any questions for Mr. Murphy?
No questions. Thank you, Chair.
Thank you. Commissioners, anything, questions for Mr. Murphy regarding what we've heard so far? All right, that means we have no redirect. So would someone like to explain why we want to enter into, are we wanting to enter into private session?
Thanks, Chairman. I think you're looking back to the company probably to start that discussion. As I indicated in our opening remarks, to the extent that we are going to discuss the company's internal policies and techniques regarding its internal monitoring process, we do believe that that should be discussed in closed session. As I indicated earlier, those are internally developed policies and processes by FanDuel. Certainly, we don't want to be out there demonstrating those to the market, including competitors. And we also believe that disclosure of the company's processes as well could potentially weaken its ability to detect this type of activity by telling employees exactly what they do and how they do it is not necessarily, we think, in the best interest of ensuring the most robust policy and procedures going forward. So we understand the commission has discretion here. This is something that is done in connection with the need to protect these types of information. And we suggest that we have a good faith basis here for doing it. And we request that the commission conduct that portion of the hearing in private session or closed session.
And Chair, I apologize for having two attorneys for FanDuel speak in succession, but just to make sure that we're being as surgical as possible in what is in closed session, we do not have an issue, Attorney Mercer, with inquiry on the play policy in terms of what's permitted and what's not permitted. Our concern is with the monitoring policy and procedure. And so that would be that second policy. I thought you were going to begin inquiring about what's generally permitted and not permitted under FanDuel's policy, which we have no issue with happening in open session. It's the monitoring policy and the techniques that we would make that request for.
Okay, I can move into that right now if that's the commission's preference. I misunderstood Mr. Nozel's initial request as far as which policies were referred to, but I can certainly do that right now.
Well, you know, our preference is to have as much of this conversation in public, so you can continue your direct examination to Councilor Mercer.
Thank you, Chair. So, Mr. Murphy, in the course of this investigation, you stated earlier that you were able to review what's been previously marked as Exhibit 2, which is the FanDuel employee play policy. Is that correct?
Yes,
All right. And this policy, the one that was submitted to the commission, is the policy that was in place at the time of this particular incident.
yes,
All right. And FanDuel requires new employees to complete a training on this policy on beginning their employment, and then they're retrained every other year, correct?
that's correct.
All right. And having reviewed the policy, could you describe some of the core features of that policy?
Certainly. Just want to make sure I have my notes here. One moment, please. Okay, FanDuel obtains the wagering history of its employees.
Oh, wait,
Is that
no, that's that would be the incorrect policy. I apologize. This would be the FanDuel employee play policy, not the monitoring policy.
employee? Okay. The one that's previously marked as Exhibit 4, correct?
Exhibit 2.
Sorry. I just don't want to say something, attorney, that should be in closed session. That's the only thing I have. My question.
Understood. Yeah, I can start off for you. Is this a policy basically that indicates that FanDuel employees are not eligible to wager on the FanDuel platform?
Okay.
I can walk you through it, Mr. Murphy, if it refreshes your memory, if that's easier.
Sure. Like I said, I like just a little bit. I know that this gets a little tricky with public.
Yep, that's no problem. Yeah, we can discuss it that way. So,
okay.
Is it true that in that policy, employees are not permitted to wager on the FanDuel platform?
That's correct.
All right. And new employees are required to deactivate any personal accounts they may have had prior to employment within 30 days of beginning their employment at FanDuel. Is that correct?
That's correct.
And in that period, despite the fact that they have an opportunity to close their personal account, they're still not permitted to wager in those initial 30 days. Is that correct?
Correct.
All right. And despite that, employees are permitted under the FanDuel employee play policy to maintain a FanDuel employee account. Is that correct?
Yes.
All right. And as part of that, employees are required to open basically a new account that follows a specific naming convention, essentially their first name, last name at FanDuel or at FD. Is that correct?
Yes, it is.
All right. And those are used for internal contests and daily fantasy sports, correct?
Correct.
All right. And the policy goes on to also outline jurisdiction-specific rules about wagering behavior that's permitted for FanDuel employees. Is that correct?
Yes.
All right. And not only does it do that, it suggests legal operators for employees to use in certain jurisdictions where they may be present at any given time.
Correct.
All right. And that policy itself does outline specific potential penalties for noncompliance for FanDuel employees. Is that correct?
Yes.
All right. And those could include adverse employment actions up to and including termination of that individual's employment, correct?
Correct.
All right. I don't believe I have any additional questions on the overview of Exhibit 2, which was previously identified as the FanDuel employee play policy. At this point, to kind of revisit where we were a few moments ago, I think that the presentation of the evidence on the IEB's end would move into Exhibit 4, which is the employee play monitoring procedure, which was subject to Mr. Nosel's request earlier.
Thank you, Councilor Mercer. I do want to give, because I gave you an opportunity to go back and
Sure.
direct, I want to give FanDuel an opportunity to redirect. Perhaps they even know some of the places they want to explore in public here. Anything addition to what?
No questions. Thank you, Chair.
All right, thank you. All right. with that and hearing Councilor Nosel's articulation earlier about why we should enter into session, let me read from 205 CMR 101.017. Let me ask a question before I start, though. Councilor Mercer and councilors, do we intend to go into this session for other parts of these lines of questioning for other witnesses?
So I would defer as far as how the expanse of the request by FanDuel at this point. I expect that this will be a detail of that policy itself, and then the steps that were taken by FanDuel in the wake of their identification of this violation. Those are pursuant to the same policy, so I would imagine that they're essentially covered under the same concerns that were expressed by Mr. Nosel earlier. But I would defer to him, or maybe defer to the commission if that goes afoul of what you expect to be in the private session. We can move back. I believe that's a brief conclusory portion of the IEB's presentation.
Let me articulate why I'm asking the question, and maybe that will help frame the answer. I am going to read this once, and then I would like to refer back to it without reading the entire 2 paragraphs over and over again. Do we intend on having additional witnesses called into private session at any point during this? If so, I'm going to say that.
Chair, the company's case in chief does anticipate reviewing the policy and specifically through witness Reginald.
All right, thank you. That was mine.
And also some of the questions I have may go into sort of the specifics that may or may not have some privacy implications for the employee at issue. So I think you have multiple options in terms of what we might talk about.
You're going where I'm going, Commissioner O'Brien. So let me read this into the record. We will decide whether we want to enter in. Commissioners, I would ask when we discuss it for the 2 other potential witnesses that I will just refer back to 205 CMR 101.017 when asking if we all agree to go into it. So let me read it. Any adjudicatory hearing conducted under 205 CMR 101.01 may be closed to the public at the request of either party or on the commission's own initiative in order to protect the privacy interests of either party or other individual, to protect proprietary or sensitive technical information, including but not limited to software, algorithms, and trade secrets, or for other good cause shown. Such a determination rests in the sole discretion of the commission. Again, that's 205 CMR 101.017. Would we like to enter in for Mr. Murphy? To continue the questioning with Mr. Murphy? I'm getting a yes across the board, so we will do that right now. All right, I think we can take the screen down. We are entering back into the public after a robust conversation with Mr. Murphy. So with that, I'm going to turn it back over to the IEB.
Thank you, Mr. Chair. At this stage, following the presentation in both the public and private sessions, the IEB would rest.
All right. Thank you. I would now like to ask FanDuel if they plan on moving forward and calling any witnesses.
Yes, thank you, Chair. FanDuel would like to call Reginald Leedon.
Please proceed.
Thank you. Good morning, Mr. Leedon.
Morning.
How long have you worked at FanDuel for?
Been at FanDuel since January 2020.
And what did you do before you joined FanDuel?
I spent 8 years at JP Morgan Chase, the last 4 in compliance.
What's your current title?
I'm the Director of Corporate Compliance.
How long have you held that title?
Since August 2024.
Can you describe for the commissioners what your duties and responsibilities are in that role?
Surely, I oversee our compliance operations team and our corporate compliance strategy and governance team in the North Star of fortifying an effective compliance program.
Have you had any previous jobs at FanDuel?
Yes, a few.
Can you just mention what they were?
Surely, I was the Senior Manager of Compliance Operations prior to this, responsible for our day-to-day compliance procedures and the monitoring and investigation. Prior to that, I was the Senior Manager of VIP and Retail Compliance, building out the frameworks for compliance procedures in both our VIP and retail spaces. And prior to that, I was the Manager over AML, helping build out our AML program.
All right. In terms of your current job, what does your team do on a day-to-day basis?
Sure. So on a day-to-day basis, it involves building out training, policy and procedure awareness, and the long-term build-out of compliance programs, also day-to-day monitoring investigations of integrity issues and employee play issues.
How many people are currently on your team?
9.
And how many of those report directly to you?
2.
How's your team divided briefly?
Sure. So one half of the house we'd say is my compliance operations team that handles that day-to-day monitoring, day-to-day investigations. And the other half would be the compliance, corporate compliance strategy and governance team, handling training awareness, program build out, program iterations, and policy and procedure updates.
Is your team responsible for administering FanDuel's employee play program?
Yes.
What is employee play, as we're going to talk about it today?
Sure. The employee play program is the entire house of the employee play policy, the monitoring alongside the employee play policy, and any escalations, investigations that have to be set forth from that employee play policy.
So let's talk about the policy. Is this employee play policy, among other things, does it cover what FanDuel employees can and cannot do both on FanDuel's platform and on other operators in the industry?
That's correct.
All right. Has an employee play policy been in effect since FanDuel began sports wagering operations in Massachusetts in March 2023?
Yes.
Is the policy updated from time to time?
Yes.
Why?
With state regulations that may change or policy enhancements, we'd update our policy.
How often is the policy updated?
At least annually. However, it could be more frequent.
We have what types of activities does the policy cover?
The policy covers internal and external FanDuel employees FanDuel employees, what they're allowed to have, internal and external, what is restricted, what is allowed in state-by-state jurisdictions.
Can you describe for the commission how employees are trained on that policy?
Surely. We train our employees in our onboarding process as they start and at least annually from there.
Is that training mandatory?
Correct.
Both for new employees and annual?
Absolutely.
Are there other resources that are available to employees beyond the policy document about what's allowed and what's not allowed?
Yes.
All right, we'll get to that in a minute. But first, are you familiar with the term personal FanDuel account?
Yes.
and employee FanDuel account?
Yes,
All right. Can you describe for the commission what a personal FanDuel account is?
surely. Personal FanDuel account is the account that anyone in the public would sign up for right now if they wanted to join the FanDuel platform.
And what about employee FanDuel account?
An employee FanDuel account is an account that is under strict regulation of our policy of what a FanDuel employee may be able to use when working at FanDuel.
I want to talk about personal FanDuel accounts. Just to clarify, is that what the violation at issue today relates to?
Yes,
Okay. So for a personal FanDuel account, does FanDuel permit its employees ever to use a personal FanDuel account on the FanDuel platform?
no. FanDuel personal accounts must be closed within 30 days.
And does the employee play policy contemplate the fact that new employees may come into FanDuel already having personal FanDuel accounts?
Yes,
All right. And what does the policy require them to do?
close that account within 30 days and to not use the account once you are employed with FanDuel.
What about existing FanDuel employees? Does the policy ever permit them to create personal FanDuel accounts?
No personal accounts are permitted to be created while FanDuel.
So we earlier made the distinction between personal FanDuel accounts, which are at issue here, and employee FanDuel accounts. What are employees permitted to use employee FanDuel accounts for?
The employee FanDuel accounts could be used for internal contests and testing on the system.
Are those employee FanDuel accounts ever permitted to be used for public-facing daily fantasy contests?
No, never,
What about sports wagering or?
never.
Okay. Are those employee FanDuel accounts required to use a specific naming convention?
Yes,
We don't need to get into what the specific naming convention is, but you mentioned internal contests that employee accounts are permitted to be used for. Can you describe for the commission what an employee contest, what an internal contest is?
sure. An internal contest could be any DFS contest that FanDuel sets up for their employees to partake in.
Are members of the public permitted to participate in those internal contests?
Never,
And are employees permitted to use their employee accounts for anything beyond internal FanDuel daily fantasy sports contests?
no.
Why are employees permitted to have employee accounts for that limited purpose?
Not only to engage in these internal contests, but also to engage with the product to provide feedback on our product.
All right, I want to switch to the monitoring procedure, and I have a few questions that I'll ask you, and then Chair, there's a small section that I would request we go into executive session under for the same reasons as Attorney Mercer had mentioned earlier. So first, before I make that request, does FanDuel have a way of ensuring that employees are complying with the employee play policy?
Yes,
And does that include ensuring that personal accounts are deactivated within 30 days and not used, and that employee accounts are being used only for the permitted purpose?
yes,
All right. Is that the employee play monitoring procedure?
yes,
Has that procedure been in place in some form since FanDuel began operations in Massachusetts sportsbook operations in March 2023?
yes,
And does the procedure change from time to time?
sure.
Why?
To improve the accuracy of what we're detailing on the reports generated.
At this time, I'd request that we go into executive session for a limited set of questions on this topic.
Thank you. Thank you, Attorney Cooper. I will ask for the record and also give you an opportunity. I'm assuming that the graphic thumbs down bubbles are not part of any testimony we should be taking in today.
I didn't see those bubbles, Chair, but no, there was no intention to have any emojis on the screen.
Chair, we'd like to confirm those didn't come from the commission though, too, so.
I don't know. I've never seen that style of thumbs down before. Like Mickey Mouse.
Dramatic. Very dramatic. I did confirm it did not come from the commission, Attorney.
Okay, thank you.
Because I was worried about that. And so
I was worried a little biased there, yeah.
So I'm reminded of the Attorney Cat video from 5 years ago at this point. But what I will say is when we move over, maybe you want to check your computer, your camera, or if you have something laying on it, FanDuel, With that, commissioners, without the recitation of the entire CMR 101.01, Commissioner Skinner.
Sorry to interrupt you. Do you want us to hold questions on the portion of the direct that we've heard so far until we return from private session?
So let's do it. You know what? Let's do it like we did the last one for consistency's sake. Let me ask first, Councilor Mercer, do you have any public redirect?
Nothing from the direct we just heard. Thank you.
All right. Now I will say any public questions from the commissioners.
I do have one question for now. What is the rationale for the 30-day deactivation requirement upon employment?
Yeah, so when an employee starts, we give them that grace period to shut down all their personal accounts as they're onboarding onto all the things that they need to know with FanDuel.
Yeah, more specifically, why 30 days as opposed to upon onboarding, or I don't know, a different number, 7 days, 14 days? Why specifically 30 days? Is there a rationale for that?
30 days was the account we felt comfortable with as we onboard an employee who's taking on a lot of things at one time. While they're never permitted to use the account within that 30 days, that's just the amount of time they have to close down their personal account.
Understood. Any consideration of changing that in light of this non-compliance matter?
We always look to update our policies and procedures and rules such as this to get the best compliance forward outlook that we can have.
Thank you, sir.
Thank you.
Thank you. Commissioner O'Brien, I see your mic's on.
I do. I have a couple of them. Commissioner Skinner asked some of them very discreetly. Who was the Director of Compliance in May of 2024?
May of 2024. You know,
when this happened?
This was a split team. When I was the senior manager of compliance operations, there was another senior manager of corporate compliance that we handled the employee play program together.
Okay. And do you recall that person's name?
Yes, Allie Frank.
Allie Frank. And is Allie Frank still with the company?
Yes.
And what role does Allie Frank have now?
She is now the senior manager of responsible gaming.
Okay. So your title, Director of Compliance, did that position exist in May of 2024?
No. Well, no. There was a senior director of corporate compliance, though.
Okay. And and that was not Allie Frank. You shared positions with Allie Frank. Who's the senior director back in May?
The senior director was Liz Barbosa.
Okay. And is Liz Barbosa still with the company?
Yes.
Okay. And was she in any way involved in the matter that we're here on today?
Not particularly. She oversaw Allie Frank's work.
Okay. And then who oversaw your work at the time?
David Speck.
Okay. And what's David Speck's title?
He was the vice president of enterprise risk management and compliance.
Okay. And then I do have a question to follow up on Commissioner Skinner's line. If you think this is more appropriate for private session, Attorney Knows will let me know. Similar to some of the questioning that she had about, the timing to wind down. Do you ask new hires whether they in fact have personal FanDuel accounts at the time of offering or interviewing?
Offering, I would have to check.
Meaning, if they're interviewing for the position or you're extending an offer of employment, do you tell them at the time that it is prohibited and ask them whether they have a private FanDuel account, a personal FanDuel account?
I'm unfamiliar if it's said at the time of offering, but when they do accept, part of their onboarding is to know that they have to close down those accounts.
So there's the onboarding training that happened a week after this individual started. Is what you're describing distinct from that?
No, that's part of the writ large onboarding process.
So am I to take it that there is no formal mechanism or process you have to tell someone at the time of offer you cannot have and you cannot continue to use or have a personal FanDuel account?
I would have to check in with our HR for that one. I do not recall.
Okay, if someone could get me the answer to that, I would appreciate it. I don't know. Ms. McKillop has that or someone else does, but
Yeah, Commissioner, we can take a look at it and see if we can get the information now, but if not, we'll come back promptly to the commission with that answer.
okay, thank you. I have nothing further right now.
Thank you, Commissioner O'Brien. Anything else from the commissioners before I turn it over to Attorney Nozel to articulate or to other counsel to articulate why we are entering in private session again? All right. FanDuel, would you like to again discuss exactly why we are entering into the session?
Sure, Chair, I'll take that. Similar to the testimony you heard, and actually probably even with more detail now with the FanDuel witnesses, to the extent that we are now going to present on information regarding the company's internal monitoring processes, methods, and techniques. We do believe that that is commercially sensitive information, the disclosure of which would put the company at a competitive disadvantage. That would include disclosing those techniques and processes which were developed internally and have value to FanDuel, to its competitors, and would potentially compromise the overall effectiveness of that by disclosing to the employee pool exactly how the mechanics on that work.
All right, Attorney Nozel. With that articulation, I'm going to repeat that 205 CMR 101.017 does allow us to enter private session for the reasons I discussed earlier. Commissioners, do we want to enter into private session?
Yes.
All right, so let's do that and continue this questioning in private. Okay, we can take that down, the screen saver. All right, so we are entering back into the public portion of this conversation. And with that, we are going to turn it back over to FanDuel to continue their direct examination.
Thank you, Chair. And just one note, Commissioner O'Brien earlier had some questions about wagering in other states. We're in the process of obtaining that information. We may not have it in time right now, but if we don't, we'll certainly get it to the commission promptly after this hearing. All right.
Oh, we just lost sound. I think, yeah. I think you might be on mute.
I may have a follow-up on that particular to this incident, sort of having nothing to do with the numbers. So we'll see if you can get the numbers, but I may have to go into, I think, probably private session and ask you one follow-up on that regardless.
Thank you, Commissioner.
We can do that sua sponte. All right.
All right. Thank you. So we've discussed earlier in your testimony the resources that the compliance team has built out over time to ensure that employees are aware of the requirements of the employee play policy. I want to explore that a bit more. But first, in general, has FanDuel over time added personnel, resources, technology, and tooling to its compliance function?
Absolutely.
With respect to the employee play program in particular, can you describe for the commission some of the resources available to employees to know what they can and can't do?
Surely. So we have an employee intranet that clearly outlines our policy right on the bottom right. We have the employee play Slack channel that gives updates, lets them know what they are allowed to do. And also we have the employee play map.
All right, I want to talk about each one of those in turn. But first, you mentioned the term Slack. What is Slack?
Slack is FanDuel's internal messaging system for communication and collaboration.
Is it available to all employees on their computers and on their phones?
Every employee.
Okay. About how many employees are a part of this employee play Slack channel?
About 1,000.
And what's a channel? What does that mean?
A channel is a group that's put together specifically for any designated purpose. In this case, employee play inquiries.
All right. What do employees use this Slack channel for?
In this channel, normally to get up-to-date information on the policy.
Okay. Do employees ask questions? Do they type them into this channel?
Yes.
And are those questions visible to all employees?
All employees.
Can you describe some examples of the types of questions that employees ask in this employee play Slack channel?
Surely. I think the most common one is, am I allowed to wager in X state, we'll say Massachusetts, or am I allowed to play casino in X state, DFS in X state?
And at no time are employees permitted to use FanDuel in any state. Is that right?
That is correct.
Okay. Are those questions that are asked answered within the Slack channel?
Yes.
Who answers them?
We have dedicated compliance employees that answer them, as well as an AI chatbot.
Okay, a chat bot. Why does FanDuel use a chat bot to, in part, respond to those questions?
We use a chat bot to ensure 24/7 coverage, really.
So are employees able to get nearly immediate answers to their questions?
Correct, yes.
And I think you mentioned this, but you have members of your team who are supervising that channel as well?
Yes.
All right. In addition to permitting employees to ask questions, are there other uses for that employee play Slack channel?
Yes, we have the employee play map, which is sent out weekly, as well as we do announcements for big events.
What's an example of an announcement before a big event and what it might sound like or look like on the screen?
Sure. So with the Kentucky Derby coming up soon, it would say, hey, FanDuel employees, we know the Kentucky Derby is coming up soon. For those interested in wagering, here is what you are allowed to do. Please click into the map and see, based on your state, based on the regulations, what is permissible.
Now, you've spoken about a map. What are you talking about there? What does that mean?
Yeah, at FanDuel, we have an interactive employee play map, we call it, where employees can go click on any state and see everything that they are allowed and not allowed to do in that state.
Where is this map located? How can an employee find this map?
This map is Slacked weekly in the Employee Play Slack channel. It's also right on our intranet, on the home where our Employee Play policy is.
So the front page of the company intranet.
Yes.
And when you say it's Slack weekly, it's posted weekly into this messaging channel?
Yes.
Okay. We'll look at it in a moment, but what information is included when an employee clicks on a particular state on that map?
The breakdown of what it would give you is DFS prohibited, is sportsbook wagering prohibited, and what are the suggested platforms for those sports books? Casino prohibited, is racing prohibited, prohibited retail locations.
All right. We have, and is the map static, or can you click and see different things based on where you?
It is dynamic and interactive based on where you click.
All right. Ms. McKillop, can we please pull up FanDuel Exhibit 4, which is an animation or a display of what that map looks like, please? Did we lose Ms. McKillop?
She's on.
Oh, yeah, she's
Oh, there she is. Okay. So there we go. What are we looking at here?
We are looking at the employee play map in action.
Okay, so this is somebody who's navigating to the Commonwealth on the map and clicking there,
Yes, that's correct.
and it tells employees, to the extent any of those products are permitted, what platforms they're permitted to use.
Yes, that's correct.
And to be clear, this is sort of on top of the employee play policy, right?
That is correct.
Which again, at all times prohibits FanDuel from using employees from using FanDuel Sportsbook.
That's correct.
All right, thank you, Ms. McKillop. We can take that one down. Last topic, to talk about the particular incident here that brings us here today. So we are testimony in the IEB's case about a prohibited play incident that took place in May 2024. Let's have a few questions about that. First, after the compliance team received a report of the employees of a potential violation, was that the end of the analysis?
No.
Did additional steps have to be taken?
Yes.
What were those steps?
After compliance was made aware, we, as discussed before, reach out to the employee with the right HR partners involved as well. We investigate the facts behind the case, get our arms around it, and try to understand how and why the violations took place.
All right. And in this situation, what did you learn about what was going on at the time with this employee?
The employee was a brand new employee and also a brand new father at the time, just getting started on both new ventures in his life.
And did the issue here, did that appear intentional or a mistake on the employee's part?
It 100% appeared like a mistake.
Did the employee appear remorseful?
Very remorseful.
With respect, and there was some testimony on this earlier, we talked about a filter being somewhat being applied in a different way. Did that change after this incident?
Yes.
Okay.
We now incorporate the first 30 days in our monitoring.
Okay. There was also, last question here, actually. Can you describe why the commission should feel confident that FanDuel has taken reasonable measures to prevent violations and to report them to the commission?
Of course. We have built out a lot of processes, monitoring and policy around employee play that continues to iterate and get better. We have the employee play policy that's updated at least annually, our employee play monitoring procedure that improves with accuracy every iteration. We have our employee play map, which, as we saw, you can click and get any of the info at a moment's notice, a wonderful employee play Slack channel that employees can access 24/7 to get any information they have. Dedicated professionals on the Slack channel ready to answer any questions, and also on our team that people can come to for any questions. And we also have staffed up to for people to review those monitoring reports and ensure violations aren't taking place.
And I know I said last question, but one more. When violations are identified, do those get referred to a team that makes reports to regulators where a violation and a report is warranted?
Yes, after we get our facts around the case, we hand everything over to our regulatory team.
For reporting purposes. Okay. No further questions. Thank you, Chair.
Thank you. I'm going to turn it to the IEB for the opportunity to cross.
Nothing further from that. Thank you.
All right, and then I'm going to open it up to the commissioners. I saw Commissioner O'Brien, then Commissioner Hill. Might go off in that order.
Sure. Just a couple questions. Circling back to deactivating the personal account, can you describe for me what's involved in deactivating one's personal account?
The employee would message our FanDuel employee play team and we would deactivate the account.
So let's say I'm not an employee and I want to deactivate the account. How do I go about doing that?
You would just send an email to our dedicated line for closing employee accounts.
Okay, so that would literally take minutes, correct?
Yeah.
And it is still FanDuel's position that you give 30 days from starting employment to effectuate that?
To effectuate it, yes. However, they are made aware that they're not allowed to wager any time within within employment.
So can you please explain to me, again, I believe Commissioner Skinner asked this question, why you think 30 days is necessary to do something that appears to take a minute or two?
We understand that onboarding is a lengthy and a new process for a lot of people. We do give that 30-day window for people to close the accounts. It's obviously preference, and they will see it when they take their employee play training to do it as soon as possible. The window is open for them to get things right, to be in compliance. However, they do know from the jump that they should not be able to wager on their personal account, and that does need to be closed down immediately.
And when I'm a brand new FanDuel employee, I take it I have a bunch of forms to fill out on day one, correct?
Yes.
And this is not one of the asks that is done on day one to simply execute that request to shut down?
Yes, I apologize. I didn't mean to interrupt. It is one of the asks.
So they're supposed to do it on day one, fire off the request to shut it down?
They have the ability, they would know in their paperwork that they should be shutting it down. They do have 30 days to do it, but they'll know that they should not be using it on day one.
I'm going to ask this another way. Has FanDuel considered mandating that the request be executed on day one when a new FanDuel employee starts?
We do continue to look at everything. And if it comes to the case that we want to update it again, we have no problem doing that. All facts gathered to make sure that everyone is in compliance.
Okay, thank you.
All right, so Commissioner Broder, I see that you're off. I will say that after we take these questions, I'm going to ask for a 10-minute break, and then we will reconvene for the closings.
I appreciate your indulgence, Mr. Chairman, because I'm anxious for a break as well. A couple of follow-ups. I'm trying to understand the logic that some of my commissioners have already asked about. And maybe there's some particular examples I'm going to try to see if that makes a difference. So it is possible when an employee joins FanDuel with an existing personal account, they might have a wager that is still open. I'll keep it simple. Someone, joins the company in May, let's say, and they've already put a wager on the World Series, which typically resolves or settles in early November. Is that fair to say?
Correct. Yeah, that could be the case.
If someone, it could be anything, like NBA championship, anything that is, MVP, the million bets, right, that people make early. If really any customer has an open wager and they ask to shut down an account before that wager is settled, what happens?
I would have to check in with our risk and trading team for that answer, but I'm happy to get that for you promptly.
And for an employee that might be in that situation, what is the expectation on them? Do they request that the bet be voided if it's an active bet?
Normally, we would see the bet while we are closing down the account, and we can take the liberty to void it for them. Sorry.
I'm just wondering, is that a possible reason why an employee might need, probably not 30 days, but might need to go in and resolve some things like that in the account?
They really don't use their accounts after joining. However, things settling and taking their money back out of it, or if they had, let's say they had funds in the account and they were closing the account, even with no wagers open, we still give them an opportunity to withdraw from their account because it was their funds.
Yeah, no, I would hope so.
Yeah.
That's for sure. So there's the potential for some level of process. I mean, I don't know if it's 30 days for someone to figure that out, but I could see Commissioner Skinner mentioned 7 days. I don't think she meant that as a hard and fast proposal. But 30 days seems like a lot, but I can't imagine a circumstance where an employee might need some amount of time to kind of unwind transactions, liquidate the account, move the money in the account to wherever they want it to go when the account is closed. Those are all things that need to be considered when you close an account.
That's correct.
All right, that's it. I'm ready for break.
Thank you, Commissioner Barber.
I do have some follow-up if anybody else. I don't want to cut. I thought maybe Commissioner Hill had unmuted himself at one point.
I did. I have some questions.
Okay.
Commissioner Skinner.
Thank you, Commissioner O'Brien. How is the training conducted on the employee play policy? Is it a live training? Is it online?
It is an online self-paced training.
Online self-paced. Could you describe it a little bit more for me?
So
I guess what I'm getting at is how is it, I'm sorry to cut you off. How is it that an employee can, I guess, not pay attention, not follow along with it as reported in IEB's report, right? What enables that behavior during a training?
in this specific circumstance, the extenuating circumstances around the employee also being a new father kind of takes a toll on how much you're retaining and what you're actually doing. I think, it's been clear how much work we put into the onboarding process to make employees aware of what they are and are not allowed to do. But, being a new father is a different challenge. And we believe that is one of the factors that played a part into the violation.
Thank you for that. So could you describe the training a little bit more? Is it a video? Is it the policy itself on the screen where you have to click through? Is there a test at the end of it to test your knowledge on what you've read and heard? Could you just give us a brief explanation of how this training is conducted?
Absolutely. So the employee would log on to our intranet. They would know they'd have a training to take. That training itself is, you click on, there are videos playing that you cannot skip through that have check questions in between some of the pages of the training, we would say. It is an interactive video. And then by the end, there's also a test that employees need to pass in order to have successfully completed the training.
I assume that's something that can be sort of converted to a document to be handed over to the commission. If that is the case, I request that.
No, I will try to get a transcript for you. It's not a problem.
Sorry, I think I just froze. I didn't hear your response. My apologies.
I said I will try to get a transcript for you. It's no problem.
Excellent, thank you. The incident according to the IEB report, was discovered or identified on May 14th. The IEB report also states that it was reported to the Sports Wagering Division by FanDuel on May 24th. Who reported to the commission? And could you explain that 10-day time period in between?
Yes, the first question for who reported was our regulatory team. Secondarily, the 10-day gap is that amount of time of my team researching, ensuring that we have the facts around the case, emailing back and forth with the employee of what wagers took place, how did this happen, getting our arms around the facts of the case, and then handing over a report to our regulatory team. All took place within the 10 days.
Okay, and was that report provided to the commission? The IEB report references an incident report submitted to the Sports Wagering Division, but it does not appear that that is an exhibit. Also requesting that that be provided to the commission.
And that's not a problem. Yeah, happy to get that incident report to you.
Okay, thank you. And sorry, did I cut someone off? Okay. I think earlier, I can't remember if it was in the public session or the private session. Did you say that this incident was the first such incident where there was a violation of this employee play policy here in Massachusetts since FanDuel launched? Did I hear that correctly?
The first and only.
The first and only. Okay. Thank you. That's all my questions for now. I mean, yeah, that's all my questions. Sorry.
Thank you, Commissioner Skinner. I didn't want to butt in at the wrong time. Commissioner O'Brien.
Sure. A couple lines of questioning. One, following up on Commissioner Broder's questioning about how long and process in terms of any pending wagers that might be in effect or monies in the account when a request to close happens. I would assume that as soon as the request to close happens, that any pending wagers are voided and the betting money is remitted back into the account. Is that correct?
It is a little more technical than that, but that is one way of wording it.
Okay. And then how long would that take to effectuate?
Not too long. I would say within a couple of days. We have our team that we work with that does all of the technical stuff of voiding a wager.
Okay. And then if I were to do that request either on the outside or as a new employee through that request, and I had money in the account, do I have to take the money out or can the money sit in the account?
We do have suspended accounts where money can sit in. When something's deactivated, normally our payments team reaches out to whatever the email address is on file and asks, where would you like the remittance of the funds in the account?
So the account can be deactivated before the person has to choose where the funds need to be remitted. Is that accurate?
In a way, the account can be suspended. If it's deactivated though, which is what we're doing in this case for personal accounts, we do tend to want to know where we're getting it first because it puts it in a limbo in our systems.
Okay. And then how long does it take to execute the request? If I said I want to check versus go back to my bank account I'm linked to.
It should all happen within the same business day.
Okay. The last couple of questions that I had have to do with Exhibit 8, the 3/17/25 email that was penned by, I believe, Ms. McKillop. So Attorney Nozel and to your team, I would direct you in particular to the second question and answer. And I ask you whether you think that's something that's more appropriate for a private session or not.
Commissioner O'Brien, we have a couple of commissioners who I think have expressed wanting a 10-minute break.
Sure.
Anyways, and this may be a good time for them to think about the response to that question and how they want to formulate that. Let me go ahead, Councilor Nozel.
Oh, sorry, Commissioner O'Brien, just so I make sure I'm on the same page here. So we're looking at an email from March 4th.
March 17th.
Okay, might be on the Exhibit 9.
It's from Ms. McKillop, I think, to Mr. Mercer.
That is Exhibit 9.
9, sorry, I had it as 8.
9.
Mine for some reason. Okay.
So,
My apologies.
you want to ask questions about question 2, correct?
And the response, correct.
the response. Okay. Yeah, let us, we'll confirm.
Great. Thank you.
Yep.
And
Thank
then
you.
let me ask this, just so I know before we go take our break. Are the cases in chief, are they rested for both parties? Are we now just to commissioners' questions, or do we have additional?
Yes, from the IAB.
Thank you, Councilor Mercer.
We didn't have any other witnesses, but we're gathering it, and I believe we'll have some answers to some of the questions that have come up, and happy to confer with Attorney Mercer and see if we can stipulate to that, or Attorney Roth has gathered some of the information from other parts of FanDuel. So however the commission wants us to put that in, we're happy to do that, but we want to round out the record so that the commissioner's questions all have answers.
And there is, by the way, there's a section that we anticipate at the end of every one of these where commissioners get final questions and answers. We always get the last word. And then, of course, closing statements also. So let's do this. Let's get together back at 12:10. Is that enough, everyone? Mm-hmm. And we will pick up where we left off. All right. Thank you.
Thank you.
Thank you.
Oh, Eileen, I do not like the office that I'm in. I have
No?
well, I'm not used to the 3 screens the way they have it set up. So you can see my head going like this to see something, and
Is it like a fun house with like the mirror room?
yeah, it's a nice way to think about it. However, as long as people know why my head's turning the way it is.
Did you hear Mango?
No.
Oh, yeah. One of the last times I had unmuted a little early and he knows it. It's like he comes in and just, yeah. He's so old, he can't jump as well, so he wants to get picked up. So he just goes to my feet and yells.
The office I'm in, the heater has been going since I got in here. So it was like 100 when I got here. Then I turned it down. Now it's like freezing in here. So I turned it back up. But it hasn't gone off the whole time I've been here.
Oh.
So I can't hear everything that I normally would hear.
Yeah.
However.
I know, it's things getting older. Yeah.
My poor dog, he's not liking this cold weather still. Yesterday.
Our dog loves it.
Oh,
she's got such a thick coat. Yesterday, she loves this weather.
My dog is totally indifferent.
Yeah.
Doesn't matter. That is
We were joking.
Super
we saw a
thick
woman
coat.
with a corgi in like one of those harness things, and she had him picked up like a pocketbook and was like carrying him outside to the tree walk. So he would go to the bathroom, and I'm just and my dog's just loving it. She's just like, whatever.
Do you like the
What kind of
snow?
dog do you have?
Do you like playing in the snow?
Yeah. What kind of dog do you have?
Me? A Shih Tzu Bichon mix.
Oh, so a little guy.
Well, he was a stray when we got him. He actually kind of came in through the health department of Melrose City Hall. So he was like the first dog for a while. Out on the street for like 4 months, like 20% overweight. Like, you must be a charming bastard. Like,
yeah.
I don't know how you did it. And he's, the teeth are all, well, most of the teeth are gone now.
Right.
How did you live?
Yeah, good puppy dog eyes, I guess.
If that's part of it. He's a charming little guy.
I will say, since we're getting back into order, that it sounds like I would not be allergic to Commissioner Broder's dog.
No, you would not.
Very hypoallergenic.
That's why we have him, because my son's very allergic. And Wilbur's cool.
Oh, what an awesome name for a little dog.
I was just going to say.
He had to be and he looked just like Wilbur the pig. Charlotte's Web. That's where it came from.
Oh, funny.
All right. We are returning to the adjudicatory hearing regarding FanDuel's alleged noncompliance. We left off with Commissioner O'Brien, and I believe Commissioner Broder had asked some questions. Let's just turn back. I just want to reconfirm. Let's do it this way. Let's reconfirm that everyone has rested, with the exception of their closing statements. And then we have a section where commissioners have questions, and I would allow FanDuel to answer any of the questions that have been brought up, in addition to any new questions. But Councilor Mercer confirming again that you've rested.
Yes, thank you, Mr. Chair.
And FanDuel.
Yes, just to confirm, Chair, we've got some of those answers, which we can do in response to commissioners' questions. There were also a few documents that were requested, the training and the incident report, which we can provide to the commission after the hearing. We would ask that the record be kept open so that we can submit those after the conclusion of this session.
That makes a lot of sense, given Commissioner Skitter's request for those documents. All right, so
I didn't know if you had looked at that exhibit, because before we actually have them read, they should have the opportunity to respond to those.
Yes, so we did look at that. Just one clarification. Ms. McKillop was conveying information that Attorney Roth had gathered and provided. So in terms of who the appropriate person.
Right. That's why I said
Um,
she appears to have been penned by her, but as we go through this, my suspicion is that someone else is really in a position to answer those.
And we do have that information that we can provide to the commission. Just to clarify, we had discussed this with the IEB. We initially did not provide it because we generally try to, our preference is to provide information to each state and to respect sort of the divisions between states. But we are happy to provide that information. We prefer to do it in closed session.
Okay, that's what I thought. I suspected you would say that. I had a couple questions on the number and the decision that I would agree with you are probably better in private session.
Thank you.
All right. So can we do this? Commissioners, do we have any questions that are right for this public session that can be answered by any party, by the way, any witnesses that are that testified today? Understanding Commissioner O'Brien has one that we've put in the parking lot. Any further questions? All right. Commissioner O'Brien, would you like for us to enter in to private session to ask those questions?
I would ask for that. Yes.
All right. And we're gonna, should we, is it limited just to that exhibit?
It's 2 or 3 questions having to do specifically with that exhibit 9, number 2. The response to number 2, both the numbers and the stated rationale.
Councilor Young, are we good for that? Okay. So commissioners, would we like to enter into 205 to private session under 205 CMR 101.017, the language I read into the record earlier, for the purpose of Commissioner O'Brien is asking the questions that she just detailed. I'm good with it. We're getting thumbs up. Commissioner Skinner, are we good?
I'm good, thank you.
All right, let's enter into that session. All right, let's take down that screensaver. Everyone a second. I know that Attorney Cooper is chomping at the bit to answer any additional questions we may have posed. But that said, I want to do it this way. It's one of the benefits of being chair. There are very few, but commissioners, do we have any other questions before we allow Counselor to address Commissioner O'Brien's question? All right.
Thank you, Chair. There was one outstanding question on when a employee or prospective employee receives the employee play policy. So in other words, when in the life cycle an employee is informed that wagering on FanDuel is prohibited. And the answer is that the employee play policy is provided to employees along with their offer letters. So at the time that they have an offer of employment, before they accept the offer and before they start, they're provided with that information. Thank you.
Thank you.
Any additional questions, commissioners, for any of the witnesses or any of the testimony that we've heard today? All right. IEB, would you like to make a closing statement?
Yes, please, Mr. Chair. Thank you to the commissioners and to FanDuel for their time today. Obviously, what we have before the commission today is an issue of a statutory violation by way of a FanDuel employee placing wagers on its platform in Massachusetts, that being a clear violation of General Laws Chapter 23N, Section 13F. Addition to that, that's fairly clear cut. This is a self-reported violation, and this is something that's pretty apparent from the exhibits that were both submitted by the IEB and the testimony from FanDuel. Obviously, a different question that we have before the commission today is the nature of the commercially reasonable efforts that FanDuel imposes to prevent that type of behavior from happening. So as the commissioners can see from the presentation of the evidence that we've had here, and then additionally the exhibits that were submitted to the commissioners, those by way of policies, those by way of communication with FanDuel, et cetera, obviously the IEB would defer to the commission in that determination of reasonableness in the measures that FanDuel has taken. I hope that the report and the exhibits that were submitted to the commission assist the commission in making a determination in regard to that. But additionally, I'd just like to once again thank everybody for their time. Thank you.
Thank you, Councilor Mercer. To FanDuel, any closing statements?
Yes, thank you, Chair, and thank you to the Commission and to the IEB for the engagement on this matter. Just by way of initial statement, I hope it's clear that FanDuel treats its regulatory compliance obligations with the utmost seriousness. A key component of that is employee compliance, which includes adhering to the Commission's rules on employee play. I hope it's also clear that we are constantly trying to get better at this. We are investing time, resources, we're putting key talent like Mr. Leeden in positions to help direct the program. And this is an art, this isn't a science. We are always trying to get better and to tune and tweak not just our policies and procedures, but how we're communicating those to employees to make sure that they are landing. So this is a case where there's really no dispute about what happened, right? That the conduct at this issue is clear. FanDuel accepts responsibility for what happened. There was a FanDuel employee. They violated the statute by placing a wager. There's no, rather, by placing wagers in the Commonwealth. There's no dispute about that. I hope that the evidence today helps the Commission put that in the broader context. On the employee's part, it very much to FanDuel did not appear to be a willful attempt to evade regulation. This was a mistake. The employee's explanation for why he missed the requirement seemed credible to those who talked to him, and also in hindsight seems credible. The employee was remorseful. As a part of this process also, and this harkens back to the theme of constant improvement and constant tweaking of the policies and procedures, we identified that, yes, it is important to have employees who violate a provision like this repay back any winnings so that they don't hold on to any ill-gotten gains. That was a learning for us from this process. We did that. We went to that employee. The employee has further demonstrated by that or indicative of that employee's remorse, returned the money, no questions asked. And we are now going to change the policy just to make crystal clear that that is a consequence of violation of this policy. But stepping back even further, the issue here, the violation took place in spite of, not because of FanDuel's employee play policy, procedure, and program. As you saw through Mr. Leedon's testimony, it's really hard to be a FanDuel employee and not to be confronted with all of the rules and regulations and prohibitions around employee play. Not just, by the way, the fact that you can't use FanDuel, but in certain jurisdictions, there are even further restrictions on which other platforms employees can and can't use. That it is in the DNA, it is swirling around. And even if you get beyond all that, which happened here, an employee places a violative wager, we're going to catch it and report it. That's precisely what happened here. There was some testimony, some discussion about how long it took to catch the wager, but the commission should have confidence that even at that time, it wasn't like employees were getting free passes. The monitoring worked. It picked up the wager after about a month. Now you have heard that wager would be picked up in the weekly monitoring. And we self-reported, right? It was referred over to the team that engages with the commission staff on matters of non-compliance. It was self-reported. Based on all this evidence, we respectfully submit that FanDuel did not violate the regulations, which impose on operators like us a reasonable standard. Was the policy commercially reasonable? Was the program commercially reasonable? The evidence shows that it was here. We developed an employee play program. We use methods to prohibit, to train employees on that. Before employees even start, they get the policy, so they should know. They're trained on that policy mandatory at the beginning and every year thereafter. It's clear and easy to read. I think if the commission takes a look at the policy itself, it's written and it's formatted in a way to be visually appealing to employees. It's not part of a 50-page policy that you read and check. It is geared towards being easily understood and comprehended. There is a Slack channel, communications channel, over 1,000 employees who ask questions and get reminders about what's allowed and what's not allowed. And we're using advanced technology like a chat bot to make sure that an employee who writes in at 7 p.m. is going to get an answer at 7 p.m. An employee who writes in at 10 p.m. is going to get an answer at 10 p.m. and that we don't have to wait to get that employee an answer. We have professional staff who's behind the scenes, who's making sure that if there are questions that are nuanced or that need additional context, that those are being addressed by the folks who know the rules and who are sensitive to the dynamics and can get answers out there. You saw an illustration of the employee play map, which I would submit is a very user-friendly and impactful way to help employees self-serve. So if they're sitting around and they don't want to ask a question on that Slack channel, they don't want to message somebody on Mr. Leedon's team, they can go to that map, click on the state, and they immediately know what is on the right side of the line and what is on the prohibited side of the line. Again, easy to use and clear. And then at the end, getting beyond all that monitoring and detection, the commission heard in closed session about the sophistication of the detection system in terms of identifying when there is a potentially violative wager. We have a team that reviews those reports. As you heard, it's not all the time crystal clear that there's a violation. Some of these things take some back and forth with an employee. And in order to make a fully informed report to the commission, we also want to understand what the disposition is with respect to that employee. And that does take a bit of time. I want to pause for a minute here and just discuss FanDuel's internal controls, which the commission took administrative notice of at the start. Those controls cover this employee play policy. They prohibit FanDuel employees or household members from creating accounts or placing wagers on FanDuel Sportsbook. They note that employees are required to attest to the policy annually and complete training at least every other year. By the way, we are exceeding that requirement by requiring not every other year, but every year, every employee to take a mandatory training on this. And we'll get the commission the content of that training so the commission can see what it looks like. But it's not a read this policy and then send an email saying you read the policy. It is a training that drives home what the requirements are. New employees are required to declare, this is again pursuant to the internal controls, to declare and close any personal accounts, and it lays out FanDuel's monitoring process. There's no dispute that these controls were reviewed and approved by the commission, and FanDuel has met and in certain situations exceeded what's required under these controls. So just to sum up here, the standard for operators under the statute is adopting commercially reasonable methods. That's the language of section 11A1. It's certainly what the commission should expect from its operators, and that's what the record demonstrated happened here. There was some discussion about the 30-day period for employees to close accounts. I think we put this in the bucket, or we would respectfully put this in the bucket of things that we're constantly looking at and thinking about improving and tweaking. And certainly as a result of this process, it is something that we're going to go back and take a look at. I would note, though, that when the commission thinks about reasonableness and promptness, that the commission puts itself in the place of a new employee starting and not with the benefit of hindsight of this one violation. Employees, when they start, essentially a lot going on. There's payroll, there's selecting healthcare, there's doing all sorts of things. And so I'm not here arguing that 30 days is the right number in a vacuum or metaphysically correct. I would suggest that it was reasonable in the facts and circumstances, but certainly it is something that we're looking at to iterate on and to see what we can do better. The other factor I'd note as a way to get comfort that this was reasonable and that the whole regime, the policy, the process, the training, the monitoring, the map, everything was reasonable, is that in the 2 years and change of FanDuel's operation in the Commonwealth, this is the one and only violation. So I would submit that all that shows that the process is working. We are constantly trying to get better, and that there wasn't a violation. And even if the commission were to find that FanDuel violated the statute, I would respectfully submit that a fine would not be appropriate here in light of the one-time nature of this violation. FanDuel self-reported this matter and all the testimony and evidence about the robust control environment that was in place at the time, that this is not a penalty case. I hope it's clear to the commission that FanDuel is committed to operating with the highest degree of integrity. It's in the company's DNA, and FanDuel's conduct in this case, as demonstrated by the evidence before the commission today, underscores this commitment to operating with the highest degree of integrity. I want to thank the IEB for its engagement on this matter and the commission for its attention. Thank you very much.
Thank you, Counselor. All right. Unless there are any further matters that the IEB, FanDuel, or my fellow commissioners would like to address, understanding we are going to keep the record open for some additional documents, we will now conclude this portion of the proceeding. Any further questions or statements? All right. Everyone have a great day, and thank you to FanDuel for coming in and for answering our questions.
Thank you, commissioners.
Thank you. Thank you.
Thank you.
And commissioners, we will move into deliberations now. We can move you into a breakout room.
Thank you.